Good morning, everyone. My name is John Cornwell, and I'm the Director of Practice Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's program, focusing on the major changes that are impacting employers early next year as a result of the Michigan Supreme Court's Daher ruling. Fortunately, we're joined today by three of Plunkett Cooney's Labor and Employment Law Practice Group members, Eric Bradbury, Brian Mitzel, and Courtney Nichols from our Bloomfield Hills, Michigan office. Before we get started, I would like to take just a few moments to provide you with some background about today's speakers and about our law firm. For those who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and most accomplished law firms with approximately 130 attorneys in our practice. We have offices in 7 Michigan cities, as well as in Chicago, Indianapolis, and Columbus, Ohio. Plunkett Cooney's employment law practice includes more than 20 attorneys who work in areas such as traditional labor law, human resources consulting, investigations, and employment litigation. Now, just a bit of background about today's presenters, and we'll get started. For nearly a decade, Eric Bradbury has been defending employers in workplace-related litigation and advising them on labor relations matters. Eric's expertise includes all manner of employment discrimination claims, and he routinely advises employers and HR pros on regulatory compliance issues. An experienced trial attorney, he's licensed to practice in Michigan and Colorado. Brian Mitzel is the go-to attorney for numerous employers embroiled in litigation involving labor and employment disputes, and he advises clients on policy and handbook issues, and he's approved litigation panel counsel for some of the world's leading employment practices insurance providers. Brian has been named a Michigan Super Lawyer Rising Star for labor and employment matters. And lastly, a partner in our firm, Courtney Nichols, serves as the leader of Plunkett Cooney's litigation department. For nearly 15 years, Courtney has exclusively defended employers in litigation and HR-related matters, and these range from ADA, FMLA, and Fair Labor Standards Act matters. She also assists with drafting and enforcing contracts, and that includes covenants not to compete and executive severance agreements. Just a couple housekeeping notes about today's program. For the Q&A portion of our webinar, we're going to use our questions tool on your GoToWebinar navigation display. So if you could take a moment now to locate it and feel free to enter, you should feel free to enter questions as they occur to you during the program. But at the end of the presentation, we're going to try to answer as many questions as possible. I know we have a lot of material to cover today, so we will take questions at the end. One of the caveats I always like to add is to please ask questions of a more general nature. We don't want to get too specific about any one workplace to protect the workplaces and keep things as high level as we can. So I hope you will appreciate that little caveat. At the end of our presentation, we're going to answer as many questions as we can. So it really does help if you get them loaded in there ahead of time, so we can kind of get those queued up for our presenters. And finally, I'm going to mention that today's session is being recorded. And that recording is going to be available on our event page at Plunkett Cooney's website, which is located at plunkettcooney.com. Feel free to share a link to the recording with your colleagues maybe who couldn't join us today. That'll be out there 24/7 for your convenience. So thanks for attending today's program. Now let's get started. I think Courtney, I believe you're kicking things off, so please take it away.
Perfect. Thank you, John, and thank you everybody for joining us today. We know that this is a big topic, a very scary topic for many, and one of the most dramatic changes we have seen to Michigan law in quite some time. So with that said, we're going to launch right in because we know that there's a lot to cover today. So I want to just provide some basic background regarding how did we end up here. So July 31st of this year, so less than a month ago, we get a big opinion out of the Michigan Supreme Court, which reinstated in some higher minimum wage requirements and dramatically changed the Paid Medical Leave Act, which will be referenced as the Earned Sick Time Act moving forward. So the decision came out 3 weeks ago. One good thing about the decision is that we have a window of time for compliance. So the laws go into effect on February 21st of 2025, and employers will not be punished for complying with the older version of the laws, the Paid Medical Leave Act, etc., until the effective dates. So that's a silver lining. With that said, how did we get here? And this is a question that frequently comes up, and there's a lot of confusion. And again, we don't want to spend too much time on it, but just to give you some basic background regarding the constitutional issues. So if you read about the Supreme Court decision, I'm sure the word constitution and constitutional popped up a lot. And the long story short is that the Michigan Constitution, as drafted, allows citizens, individuals, to bring an initiative forward which can become new law upon it being voted upon. So this gives people a direct opportunity to initiate legislation. It's relatively infrequently successful. So often the majority of our legislation is coming from lawmakers and not from citizen initiatives. The Constitution reserves the initiative power to the people and limits the legislature's role with respect to this citizen initiatives process. The legislative role is limited to what rights have been specifically conferred to the legislature, again, under the Michigan Constitution. So that's just the basic background and the framework upon which we are all here today. So then there's two proposed initiatives that come out in 2018. So those initiatives related to the Michigan minimum wage and related to the Earned Sick Time Act. When an initiative is brought forth, the legislature has three options. They can adopt the original citizen initiative. They can reject the initiative and it goes on to the upcoming ballot, or they can reject or amend portions of the initiative and the new and original version of the initiative ends up on the ballot. So that's what the Constitution says in terms of citizen-led initiatives. So again, we have two in 2018, and what ended up happening was under what people will refer to as a Republican-led legislative majority. There was an adopt and amend process where after the initiatives were drafted by citizens, the legislature adopted them and then amended them after the election. So basically they adopted before they were voted upon so that they could adopt and amend and then make modifications not only to the amounts under the wage provisions, but a number of definitions under the Earned Sick Time Act and effectively push back the timetable of enforcement, obviously including the minimum wage. So this was an adopt and amend measure. In 2018, this was a quick education on many people who had really no understanding of citizen initiatives and adopt and amend because, again, it's infrequently applied. So this occurred. It had been challenged a number of times in a number of ways, but between 2018 and July 31st of 2024, the courts had continued to allow employers to abide by the provisions of the amended initiatives and not the citizen initiatives. So then what happens next? We get the case at hand, which Brian Mitzel is going to talk about.
I don't know what I did to upset my colleagues to talk about the 104-page Michigan Supreme Court opinion that is the case at hand, but here we are. I'll talk about more interesting things later, but just to carry on with what Cordy was explaining, and Cordy, correct me if I'm wrong, I think the initiative that you were talking about with citizen proposals, that's how recreational marijuana got on the ballot for Michigan, just to kind of bring it full circle for everyone. You know, it's used very infrequently, but sometimes it does occur, and this is one of those cases. There wasn't an adopt and amend challenge like there is here today for these acts, like there wasn't for the recreational marijuana laws, but that's, I think, another instance in which it was used. But so ultimately what happened, Courtney explained that these were proposals that were in 2018, and we're here in 2024, and they've resurged. So what I'm going to give you is just a little bit of background about how that happened, going off of what Courtney said. So in August of 2022, there was an action brought in front of the Court of Claims. The Court of Claims in Michigan said that the adopt and amend challenge was unconstitutional. That was then brought in front of the Michigan Court of Appeals. In January 2023, the Court of Claims opinion was reversed, and then ultimately it went to the Michigan Supreme Court. Finally, as Courtney mentioned, July 31st, 2024, the Michigan Supreme Court, in a 4-3 decision, decided that yes, the adopt and amend action that was taken by the legislature was unconstitutional. One interesting kind of little factoid there, I think I work with a lot of you, or a lot of you might have these questions when you are going through litigation. And one thing that's always hard to communicate to our clients, or can be difficult to communicate, is how long a case might proceed. Questions we often get asked are, what's this going to take? How long is this going to happen? I think this is a really good snapshot. Obviously, not all cases go to the Michigan Supreme Court, but this is a good example of how the legislative process works and how long it might take for something to start and then ultimately finish. I mean, we're talking about proposals that were adopted and amended in 2018 and will become effective February 21st, 2025. So just to put in the length of a case and how litigation proceeds, it takes a long time. So take that with a grain of salt. But then moving on to the holding itself, the ultimate decision is that the adopt and amend procedure is incorrect and that it's unconstitutional and not allowed by the Michigan Constitution. As a result of that, what the reason for a lot of the questions we get is why February 21st, 2025? Is that a random date? What's going on with that? And what the Michigan Supreme Court tried to do is kind of rewind the clock a little bit. So when the 2018 proposals were adopted, they were to become effective in 205 days. So what the Michigan Supreme Court did is said, fine, they're going to be effective 205 days from our opinion. So that's the July 31st opinion, and that's the rationale for the February 21st, 2025 effective date. So essentially what happened is the can got kicked down the road a little bit, and we're going to discuss what are the implications of that, especially with inflation and everything else going forward. So the Michigan Supreme Court essentially took up the case and said, hey, this is still going to be good and it's going to be effective, and we're going to carry off where we left off. So it's kind of like a big pause button that happened, and the Michigan Supreme Court unpaused it for us. So that's what's going to happen, but I believe Eric's going to talk about the Wage Act now for you.
Yeah, thanks, Brian. So one of the two initiatives that we're here to discuss today, obviously, is the Wage Act. And when the Supreme Court majority wrote about the Wage Act and described sort of the changes brought about by the initiatives that the court was weighing in on, the court described the changes to the Wage Act as, quote, significant changes to Michigan's minimum wage and overtime laws. And I think that's both fair and maybe also kind of an understatement. So when I read the court's opinion and when I think about the changes to the Wage Act, I sort of think about three main categories of changes to the minimum wage laws, if you will. One of the categories is that the new Wage Act brings about incremental increases to the minimum wage, which I'll talk about in more detail in just a moment. Sort of a second category of change brought about by this new Wage Act are annual increases to that wage based on inflation once this gradual phase-in is complete. And then kind of a third category is increases in the minimum wage for tipped employees, which will be a big change, of course, for employers who employ those types of workers. So thinking about what are some of the big takeaways that we hope employers will take from this presentation, and especially when talking about the Wage Act, we're talking about those employers who employ folks at the minimum wage or near the minimum wage, and also those who take advantage of the tipped credit. So the first takeaway is that the wage rates brought about by this initiative are effective with adjustments for inflation, which we'll discuss. And one of the reasons that the court needed to consider inflation is because the schedule that was originally designed to go into effect is already outdated. For example, in 2019, the phased-in minimum wage was scheduled to be $10 per hour, and as many of you know, the minimum wage in Michigan is already greater than that. So we'll talk about that in just a bit more detail here in just a moment. Another takeaway, which Courtney mentioned, is that the wage rates, just like the medical leave provisions, will go into effect February 21st of 2025. So in that sense, the court did employers a bit of a favor, offered a bit of a silver lining in not making these wage rates effective immediately or with a very little lead time. There is some time to process these changes and ensure compliance. And another key takeaway here is that employers will not be penalized for having followed the law as it was written. Instead, we want to make sure that we get compliance in place in time by the February 21st, 2025 effective date. So I mentioned a moment ago that the phase-in for minimum wage will take place over a period of years. And that was the design built into the initiative as drafted by the citizens. Originally, that phase-in schedule was designed to begin in 2019 and gradually go into effect through 2023 to the point where the minimum wage would have been $12 and then adjusted for inflation after that. When the court was deciding what to do in terms of how do we go forward most effectively, the court decided that adopting that same model was the best plan in terms of phasing in over time rather than right away. And so essentially what we're left with is the court telling employers and everybody else that we're going to treat February 21st of 2025 as if that were the initial phase-in date of 2019. And then we will incrementally increase in 2026, 2027, 2028, and so on. Now, inflation, of course, is a big factor here because, as I mentioned a moment ago, the wage rates written into the initiative are already outdated. And so this is one of those areas where there is still somewhat of a question mark, but what the court directed the state treasurer to do is to calculate inflation rates using existing procedures that require the Treasury Department to publish the amounts by November 1st of the year the calculation is done. In short, what that means is we expect more information about the state's inflation calculation and what amounts will actually be tied to these incremental increases later on this fall. The Wage Act also brings about some changes, as I mentioned a moment ago, for tipped workers. There are a few new requirements that employers who take advantage of the tipped worker credit will need to be aware of. Just to sort of go through those quickly. One is that the entire gratuity earned by tipped workers will be retained by those workers who receives the tips unless as part of a voluntary tip sharing program that might be shared with others in the chain of service who are not managers or supervisors. And the other sort of change brought about to the tipped worker credit is that the employees who participate in that will need to be informed about the new law on gratuities in writing, either when they're hired or before they're hired, and they'll need to give their written consent. Now, for tipped workers, just like the minimum wage phase-in schedule that I mentioned a few minutes ago, the phase-in will take place over time, but know that the end goal here of the initiative is for tipped workers to achieve 100% of the minimum wage over time. So whereas now the minimum wage is 38% of the minimum wage, when this initiative is phased in initially in February of next year, that percentage will be 48% of the minimum wage. That'll increase to 60, and then 70, and then 80 as the years go on, until eventually tipped workers earn a minimum wage just equal to everybody else. With that, I think we'll pass it to Courtney next to talk more about the Earned Sick Time Act.
So I'm sure this is everybody's favorite subject, the Earned Sick Time Act. So what I'm going to be walking through are the changes from what we all have come to know as the Paid Medical Leave Act and what we are going to be required to do pursuant to the Earned Sick Time Act, which is going to be effective in February of 2025. So jumping right in, there are big changes right out of the gate to the definitions of both employers and employees. So as an initial matter, all employers are covered regardless of size, whereas under the PMLA, only companies with 50 or more employees were covered. So again, all employers are covered. Likewise, all employees are covered. The only carve out is employees of the US government. So that means any individual who is engaged in service to an employer in the business of an employer. Now, we do not have regulations. We don't have an FAQ or fact sheet yet. We will likely get those. But that definition of employee closely mirrors the definition of employee that you see in the Fair Labor Standards Act, which is, an individual who is suffered or permitted to work for the benefit of the employer. So you can see, again, somebody that's engaged in service, somebody that's suffered or permitted to work. There are probably going to be joint employment issues. But for now, I expect that is going to be construed as broadly as possible with the intent to provide coverage to as many people as possible under the applicable law. So we no longer have exclusions for exempt employees. We no longer have exclusions for people that are working on average less than 25 hours per week. We no longer have exclusions for individuals that are seasonal, right? So all of those sort of exclusions that were sometimes a little gray and sometimes very clear, those are all gone. A very simple definition of employer and a very simple definition of employee. So assuming you all are going to be covered and all of your employees are going to be covered, the next questions relate to, okay, well, what does that mean in terms of accrual and usage? So the accrual has changed. So before it was 1 hour for every 35 hours worked, and what most companies were doing was front loading 40 hours of time or capping it at 40 hours of time, which was allowed under the Paid Medical Leave Act. That is no longer the case. So employees may use up to 72 hours of earned sick time per year. There's no cap on accrual and there's no cap on carryover. Okay, so for large employers, you have to pay 72 hours. There's one little caveat in terms of, again, not usage, but payout, and that's for employers with less than 10 employees. And again, that's a very specific definition. Only 40 hours must be paid. So that's 10 employees in a given week. So if you're fluctuating, if you're over 10 in other weeks, it could be a problem. Again, we should get more regulations on that. But the vast majority of people here today and individuals that we interact with are going to be in this situation where it's 1 hour every 30 hours worked, usage of up to 72 hours, no cap on carryover. Okay, so those are big changes. In addition, there's a big change in terms of how small the increment can be for usage. So under the Paid Medical Leave Act, most of the time it was an hour. So if somebody was gone for 30 minutes, they would still use an hour of leave. Now employees are allowed to use leave in the smaller of hourly increments, or the smallest increment that your payroll system uses to account for absences or use of other time. In Michigan, most companies are using 6-minute or 5-minute clocks because of our rounding rules. Some companies may use different and avoid Michigan implications if they're not here, but you're looking at, for most companies, allowing earned sick time at a 6-minute or a 5-minute increment. Again, unless there's further clarification, we've got to look at how does your payroll system track time, and that's what's going to be allowed. So that will just result in, candidly, a lot more usage and probably what we would relate to an intermittent leave type of usage of the earned sick time. So as it relates to the rollover, which is what I mentioned, so all unused earned sick time is going to roll over. So right now, under the Paid Medical Leave Act, if you front load the paid medical time, you don't have to allow for rollover. That is gone. So that, again, sort of benefit for employers in many cases will no longer exist. Now, one, again, silver lining is that they can roll over up to the cap, or up to the accrual amounts, but they can't necessarily use more than that. So say, for example, somebody has accrued 72 hours. They've worked a ton. They've accrued 72 hours. They haven't used any of it. They can roll that over from 2025 into 2026. There's no cap on what they're accruing, but they can only use 72 hours. So they might have a bank sitting there with 144 hours of available time at the end of 2026 if they worked a ton of hours and never used a minute of the time in 2025 or 2026. But going into 2027, again, you can cap the usage at 72 hours. So it's an inconsistency, which again, this might be modified by an appropriate legislative act, but for now, this is how it's written in. They're really, front loading has very little benefit in terms of providing you with an out from these numbers rapidly rising. Front loading does have a benefit in the sense that if you're trying to ensure that you're front loading more than they're going to accrue, it might have an accounting upside. But really, I think most companies now are going to be going to a system where you have separate accruals and a separate bank of earned sick time to make sure that this is all tracked, because accruing and using are going to be, in my opinion, the two things that are most closely monitored and probably the easiest areas for employers to run into compliance issues, especially employers that have payroll systems that are automatically capping usage or automatically capping accrual under the Paid Medical Leave Act. We have to make sure that that's all modified before we get into February of 2025. Continuing on to further changes, the documentation processes have likewise been modified. So you can request documents to substantiate a need for earned sick time, but only after an absence has been for 3 or more consecutive days. Okay, so that's a change from the Paid Medical Leave Act. So if somebody says, hey, I have a doctor's appointment on Thursday, I'm going to need to use my earned sick time, that you don't have a right to get proof of that doctor's appointment under the Earned Sick Time Act. So if somebody says, I'm going to be out for 4 days for a back procedure, then you're dealing with 3 or more consecutive days, you can get documentation in that case. So from my perspective, as an employment attorney that is frequently reviewing potential compliance issues and consulting on problems that arise in the workplace, I think it's very important that all employers on this call are making sure that your supervisors, your frontline supervisors, your management, individuals that have become accustomed to asking for doctor's notes or that think they have a right to get doctor's notes in every single case, know what they can and cannot get. If we have frontline management or middle management or individuals demanding doctor's notes or saying that they're not going to approve the time unless they have documentation to substantiate, then they're walking right into a violation of the Earned Sick Time Act, which, per the second bullet point, main bullet point here, provides a private right of action. This is, again, a big difference from the Paid Medical Leave Act. What does that mean? A private right of action is a fancy legalese way to say they can file a lawsuit against you directly. So nobody on this call has ever, I would assume, been sued under the Paid Medical Leave Act by any employee, because the process before was that if they felt the Paid Medical Leave Act was violated, they would have to go to the state wage and hour division, file a claim, and then the government would do a review, very similar to like a wage and hour type of internal government investigation. Now there's a private right of action, which means that an employee who believes that their rights have been interfered with or that they've been retaliated against in violation of the Earned Sick Time Act can go to a plaintiff's attorney and file a lawsuit against you in state court. So that's a 3-year statute of limitations period. Again, think about this akin to the FMLA. If an employee believes that they've been improperly denied FMLA leave, they could go to the United States Department of Labor and file a government complaint, just like employees in Michigan can still go to the Wage and Hour Division and file a complaint. Or they could go to federal court and file a lawsuit under the FMLA. The same is now true. They can go internal government, or they can go immediately to file a lawsuit. So something that we really need to think of as we move forward, and we're wanting to ensure that we've trained management appropriately. So these are the primary issues. In terms of a couple of other things that I want to point, that covered reasons and covered family members, which is on the next slide, but covered reasons. So the PMLA and the ESTA are going to be very similar in terms of the various reasons that employees can utilize the paid time off. The ESTA adds an additional reason, which is a meeting at the employee's child's school or place of care related to the child's health or disability, or the effects of domestic violence or sexual assault on the child. So the most common example of this is clearly going to be IEP meetings, right? So now any employee that you have that needs to leave to go to an IEP meeting, which are pretty common at their child's place of school, that's going to be a covered reason. So again, management needs to understand this, and individuals who are reviewing time off requests and disciplinary requests need to understand that this is all going to be covered. The child's school, for me, is going to be really difficult for companies to wrap their arms around, because as somebody with 2 children, there can be very frequent meetings, there can be infrequent meetings. So, trying to figure out how long, when those happen, and understanding, again, our limits on the documentation that we can request is going to be really critical moving forward. Another change worth noting, but not a massive issue, is the addition to family members. So keep in mind, when you see all of these changes, there's one goal in mind, and that's to provide as expansive coverage to employees as possible. So we've expanded the definition of family members to add domestic partner and to add any other individual related by blood or affinity whose close association with the employee is the equivalent of a family relationship. So that gets added to what you saw before: child, parent, spouse, grandparent, grandchild, and sibling. I think practically what that means is that you're going to have people who, for example, have a close relationship with an aunt, with an uncle, with cousins, who they said, we grew up together, we're akin to siblings, and I need to help provide care for my cousin, my aunt, my uncle, my nephew, my niece, etc. So another thing to train all those folks in human resources and management, if somebody says, I need to go take my cousin to this appointment, I need to go provide care to my cousin, the knee jerk of that's not going to cut it. Like, you don't get leave for that. Can't do that anymore, right? We have to take a deeper analysis and figure out if this is somebody that's going to be considered a covered family member, which I believe in most cases the answer is going to be yes. And your ability to really push and question that is going to be pretty limited. So that's a lot. The key takeaways for me when we look at this is, that while the PMLA really gave the employers opportunities to push back, to get documentation, to narrow, we don't see that anymore, right? We even see that with a common topic, and I expected that this question would be asked, but under the PMLA, almost all of my clients have one block of PTO, and it's 60, 80 hours, whatever it might be. And there's a caveat in the handbook. There's a note that says this is for usage for any reason allowed under the PMLA in addition to your vacation and your personal days. So if you have somebody with 80 hours of vacation and they choose to take a 2-week trip to Spain, under the current process, we would not provide them any additional paid medical leave. Likewise, if you only provided 40 hours, if you weren't even at 80 hours, but you provided 40, that's the max. If you choose to take a 1-week vacation to Florida and then you get sick 3-4 months down the road, you're out of luck. That rebuttable presumption is something that we have not seen any specific comment on from the Wage and Hour Division. And as it's currently drafted, it's our opinion that if you're trying to use a non-sick paid leave or paid time off policy, you have to provide other paid leave in at least the same amounts that can be used for the same purposes and under the same conditions as those called for under the ESTA, and that's accrued at a rate equal to or greater than the rate under the ESTA. So you're looking at, in my opinion, a pretty difficult process when you compare, most PTO policies to what the EST is going to require in terms of accrual and usage. I have already started to get the sense that I think companies are going to start breaking up once again, sort of going back to what we saw 10, 15, 20 years ago, a separate bank for prepaid vacation time and a separate bank for earned sick time with the vacation or the pre-planned vacation. The vacation, more requirements regarding advance notice, scheduling, things like that. Earned sick time, you're addressing it under that law, which is obviously far more employee friendly. So this is an area where I think we're going to be diving into the weeds with a lot of our clients over the next 3 months to try to iron this out before January 1st. And it's something that I would encourage everybody to talk about internally at their business to determine, how they want to handle this in terms of breaking up the banks for process of administration and compliance. I expect there's going to be facts on this, FAQs, as I mentioned, and that we're going to get some specific responses dealing with that rebuttable presumption. But until then, the best thing we can do is figure out what's going to be the most practical solution for our clients and something you can actually implement and ensure is being consistently enforced. So one bank, in my opinion, at least at this time, 3 weeks after the opinion, I think it's going to be really difficult for a lot of clients, especially when you're going to have so many more employees that are entitled to earn sick time than ever before, and really sort of a dramatically different process. Whereas, sort of keeping PTO for that personal vacation and then separating earned sick time for administration might be easier to explain and walk through. Just things to think about. But these are big questions, big issues. What we're happy to do is to and I believe it's something that we're going to be working on over the next couple of weeks, is breaking down a chart so everybody can see, what happened under the paid medical leave, what do you have to do under the Earned Sick Time Act, because these are significant differences. All right, and we have some additional comments. So walking into, sort of what other things to think about is going to be Brian.
Thanks, Courtney. So Courtney already alluded to the very broad definition of who's an employee, who's an employer under the acts that will be newly effective. And I know from the attendee list that we have today, we have some public employers who have public employees. And previously, they might not have been as concerned or concerned at all about some of these acts and some of the implications because a public employer, a public employee was previously excluded under the PMLA. That is no longer the case under, for example, the ESTA, where the only exception is the U.S. government, as Courtney already stated. So it's a big shift in what's going on collectively for employers and employees in Michigan, regardless of whether you are a private employer or a public employer. These are now collective concerns that we all have, or collective situations that we all have to deal with. One thing about public employers is there are other acts to consider. For example, MCL 408934. There could be some exceptions, for example, for fire protection, law enforcement, correctional facilities, and there needs to be a deeper dive into whether those exceptions apply. So that is also something to consider. Even in the grand scheme of public employers, there might be some little exceptions to work through. So as a public employer, you need to make sure that what you're applying, what you're changing is applicable to the employee at issue. And we'd be more than happy to help you through that. Another implication is anyone covered by a collective bargaining agreement. Again, previously, someone under a CBA, a non-issue, the people under the CBA collectively bargained and they came to an agreement on some terms, on some agreements, on some procedures, and that was going to be effective. But that's realistically no longer the case. So the ESTA, for example, the Earned Sick Time Act that Courtney was talking about, will be effective for an employee covered by a CBA at the expiration of a CBA. So February 21st, 2025 is the effective date of the act. If you have employees that are covered under a CBA that expires on February 22nd, 2025, the next day, that's the new floor for those employees. So what does that mean? I mean, for any ongoing collective bargaining that is going on, any renewals, any discussions, what these acts really do is it raises the floor if the CBA provides less than the acts we talked about today. So it really does implicate it. Even if you have a CBA that expires, a year from February in 2026 or something along those lines, what has happened is collectively the floor for employers and employees has been raised. So all collective bargaining agreements and negotiations will change and shift, and what is provided by statute will be the floor. So we anticipate that a lot of these discussions will happen. It might be difficult to negotiate with employees or their representatives that are covered under CBA if it's below what is provided under the act. And that's where leverage and discussion really needs to take place to make sure that as an employer, you are protected and that you are putting forth what is best for your company and everybody else. Finally, we've had questions in the interim since the 3 weeks since this decision came out, and now is whether or not all this unused sick time that has been accrued has to be paid upon resignation, termination, any type of separation. The answer right now is no, but as I mostly counsel my clients, sometimes that's a good opportunity to include it in the severance agreement. I typically counsel that severance agreements can be effective to avoid any sort of future litigation. With all this new earned sick time, unused sick time that everyone is accruing, unless your policy says different, under the law, it is not required to be paid upon termination. But that doesn't mean we can't use it to leverage a severance agreement and say, yes, we will pay you the X hours that you earned, but sign this document and avoid any sort of future litigation. That's one thing we can use all this additional time for, to hopefully benefit you as the employer, as the client, and avoid any future litigation, which I'm sure most of you know can be more costly and more time consuming. But so that's one of the things that we'd like to try to see come out of this, to be proactive to avoid future litigation resulting, especially because, as Courtney already mentioned, there's now a private right of action under the ESTA, meaning, of course, that you can be sued for it, and that could result in a rise in litigation. But we do have some other questions that were asked to us before this webinar took place. So I think Eric's going to take the first handful here. Thank you.
Yeah, thanks, Brian. So, not surprisingly, when the news started flying around about these initiatives and what the Supreme Court did in its decision at the end of July, inspired a lot of questions. And so, what we wanted to do was go through some of the frequent questions that we're receiving. And one, or at least one of the themes that we're hearing is, well, how do these changes, especially to the Wage Act, affect exempt employees? And of course, we're talking here about exempt versus non-exempt employees. And so I guess a bit of good news, and maybe another silver lining, is that the Wage Act does not make changes to the classifications about who is exempt or who is non-exempt under federal wage and hour laws. And of course, when we talk about exemptions, we're talking about some of the big ones: executive, administrative, professional, that many of you are familiar with. So the important takeaway here is that when we're talking about changes to the Wage Act, we're not talking about changes to who is exempt versus who is non-exempt. We're just talking about changes to the wage rate for those who were previously non-exempt or hourly and continue to be. So no changes essentially to the exempt folks who you pay on a salary basis. Another one of the questions that we're receiving, or among the themes that we're receiving, and Courtney talked about this in her discussion about the ESTA, but it's this issue of accrual, and what about folks who are newly hired? So to kind of break that down into two answers, I guess, based on the two initiatives that we're talking about. There really isn't the concept of accrual under the Wage Act like there is under the ESTA. Of course, when you hire somebody and you start paying them an hourly wage, they start earning when they're hired. The one caveat is that there is an existing carve out for employees under the age of 20 who can earn a training wage for the first 90 days of their employment, and that will continue to be the case under the new version of the Wage Act. And then with regard to the ESTA, as Courtney discussed, the effective date of the law is February 21st of 2025, and accrual will begin then, if not sooner, at the employer's option, or if an employee is hired after that effective date of the law, then they begin accruing when they become employed. Another one of the frequent topics that we are hearing from folks about is curiosity about carryover and caps. Courtney addressed the ESTA, and so I won't go through that again, but I will mention with regard to the Wage Act, in lieu of overtime compensation, they're in the existing law and in the new version of the Wage Act, there is the concept of compensatory time that employers can pay, and compensatory time is capped at 240 hours total. So there really aren't many changes to the notion of compensatory time under the new version of the Wage Act. But one thing for employers to be aware of is that, yes, there is a 240-hour cap, and another is that employees can request that they receive a payout of their compensatory time or a portion of their compensatory time. And when employers receive those requests, they need to comply, and they need to comply by paying out within 30 days of the request. So with that, I think I'll pass it to Brian for the next batch of questions we're receiving.
So thanks, Eric. So we did receive a lot of questions regarding whether or not the laws apply to somebody under a CBA, collective bargaining agreement. And I kind of touched on this earlier, but the answer is expressly yes when it used to be expressly no. We want to be very clear on that. It is a change in the law. And the when is a case-by-case analysis, right? So the when it applies will change for likely any one of you that has employees that are under a CBA. So if you have any questions about that, please feel free to reach out to us. We can provide you an analysis. And the biggest thing I think to remember regarding whether or not there's an implication with somebody under a CBA is the floor is now raised. If the CBA provides less than what these new acts provide, the floor for negotiating has been raised, and nobody that is, anyone that's paying attention is going to up their negotiations for what is expected of their employer based on what the floor is as set by these new acts. So we just want to be very clear on that. And then finally, we got a question that is the act beyond what we already offer? And again, that's case by case. It could be what the law provides, just like if you do a Fair Labor Standards Act analysis, right? So federal minimum wage is, $7 and something. Michigan minimum wage right now is $10.33. As a Michigan employer, you're paying Michigan minimum wage. The floor, a state can always pay more than what the federal law applies for. The same is true for a policy for an employer, whether you're public or private. You can instill a policy that provides more than what the law allows, but you cannot go backwards. You cannot go less. Michigan minimum wage can't be $6 because that's below the federal minimum wage. The same is true for all these new rules. So the Michigan law is now the floor. As an employer, you can provide more coverage, more protection, more whatever, more pay than what the floor is at, but you cannot go backwards. So it's a really important time from now till February 21st, 2025 for employers to review their policies, make sure they are meeting the floor, and adjust as appropriate. So thank you for your time today.
And with
Okay,
that,
yep, go ahead.
sorry, John, I was just going to say, with that, and before we wrap it up and allow for some audience questions, I just wanted to note a couple of things, big pictures. I know that, when Eric's talking about wage rates and I'm talking about paid sick time, I just want everybody to keep those things separate. Okay, so for example, the wage law modifications are not changing the exempt status definitions, but exempt employees are now covered under the Earned Sick Time Act. And also note that what we're here talking about right now are changes under Michigan law. I'm sure everybody on this call is aware, but the Department of Labor has issued a final rule that has modified the salary thresholds for the white collar exemptions under the FLSA. The first threshold increase was effective July 1st, and there's going to be more increases beginning in January of 2025. So I'm not trying to pile on, but what we're here today talking about are two specific and separate Michigan issues: wage changes, things that affect compensatory time, minimum wage, tipped credit, earned sick time, second, paid medical leave. Nothing to do with the federal changes, which is a whole host of other issues that we will have to talk about on a separate day. But with that, one of the things that I wanted to talk about was, and just mention, is keep in mind, we're talking about payout of sick time and wages, but there could be other things in the soup here. So John, if we have a second, I was going to have Denny Boren, who's another new member of our Plunkett Cooney Labor and Employment team, and an individual with extensive experience with the National Labor Relations Board chime in regarding, what he is concerned about in terms of modifications and what's going on in employment workplaces right now.
I believe I've given Denny the permission to speak. So Denny, could you try to say hello to the group and jump in here? Using some new technology here, so just give us a moment. I want to make sure.
And if it doesn't work, I know what Denny was going to say, and I'm happy to chime in as well. So,
Denny, is your microphone muted?
well, let me do this. Let me chime in because I know that all of our attendees are on a tight schedule. So for those of you that aren't familiar with Denny, I'd encourage you all to look up his qualifications, but he was the top attorney with the National Labor Relations Board for several years here in our Detroit region. So he knows the ins and outs of how they deal with issues and the issues that come forward. And we've had conversations since these laws were modified about concerns that, that employees who are engaging in concerted protected activity are protected under the National Labor Relations Act. So what that means is that employees that are complaining about sick time, that are complaining about minimum wage or tip credit, that are talking about how to get sick time, how to use it, all of those conversations that we expect is going to be a form of concerted protected activity. So another thing to just be cognizant of is that we are seeing a huge uptick in charges filed before the National Labor Relations Board alleging retaliation in violation of the employee's Section 8 right to be able to engage in that concerted protected activity. So even for non-unionized workforces, we are seeing these charges all the time. So I just encourage employers that are dealing with complaints or issues or employees discussing this in the plant, in the workplace, to really make sure that you are consulting and being extra careful before you do anything that could be deemed retaliation, either under the laws themselves or under the National Labor Relations Act.
Great. We do have a number of questions. I did pick out one here. We only have a couple minutes left, and let me assure everybody who asked a question, we will get back to you on those questions after the event. But this one was asked in a couple different ways, so I'm going to go ahead and state it. This is regarding paid medical leave. If we create a separate bank for paid medical leave, do we need to pay out upon termination of employment?
So do you have to pay medical leave? So let me, John, sorry, just to make sure I get that right. Do we have to pay medical leave or earned sick time? The answer is very clearly, unless you have a written policy or document, contract that you have given to employees that say we will pay out your accrued and unearned sick time, you do not have to pay it out under Michigan law. So the earned sick time initiative, the one break for employers that we got in that law is that there is a specific provision that you don't have to pay out like monetary compensation for time that is accrued and not used. So unless you are putting in a policy, a handbook, something to the contrary, you have no legal obligation to do so. With that said, I'm sure everybody here is going to be modifying their policies. I would make it very clear in your handbooks exactly what happens to pay time off at the time of termination. And that would include vacation time, it would include personal days, and it would include sick time. Because this is something that employees consistently bring up in a discussion that is often had at the time of termination. So I put in your policies, and honestly, I'm even carving out separate language in that effect in acknowledgement forms, because it's such a common question, an area of pushback that we get.
Great. Another question that came up I thought was interesting is, will ESTA hours be counted towards overtime?
As hours worked? No, so I believe the question is, do we have to count the time that an employee has taken for earned sick purposes as hours worked when determining whether an employee has worked more than 40 hours in a work week for overtime purposes? My opinion on that, again, is unless you have a specific policy or procedure stating that you will do that I would view it no differently as any other form of time off. And the FLSA is clear that when you're calculating time worked, it's time that is suffered or permitted to work. So like under the FLSA right now, you don't have to calculate, add in FMLA or vacation or holiday or sick time. I've seen nothing about the earned sick law that has attempted to make a differentiation there. Again, if we get a regulation or an FAQ that states otherwise, then we will certainly let you know. But for now, I would draft all of your policies and procedures, including earned sick time, as another form of time that doesn't count towards hours worked, because it is not, in fact, hours worked under the FLSA.
Great. I'll just tell the presenters there are a number of other questions in the queue, so we've flat out run out of time. So what I think what we'll do is we will definitely review those offline, and for all of our attendees that were here today, we'll share those answers with you as best we can. Some of them have been already tackled today, but for those that we haven't, we will definitely work that up for you and try to get that out to you after we wrap for today. So at this point, what I'd like to do, if it's okay, I'd like to just kind of wrap up. We're at our 1 hour time frame. Just letting everyone know who attended that when you log off, you will receive a webinar survey. We really appreciate your feedback, especially any topics you might suggest we cover in the future. We review all of that feedback and really use it for our future programming, so we would appreciate it. Today's webinar, again, is going to be archived on our website. There's an event page for it. And if you missed anything, want to repeat any of the information, I know there were a couple people in the queue asking to repeat some information. Take a look at that recording first, and if you still need some help after that, you can certainly contact one of our speakers. Just simply go to our website, and if any colleagues couldn't make it today, feel free to share that link for the recording as well. One little plug, we do cover a lot of employment topics on our blog, The Sophisticated Employer. We encourage everybody to check that out on our website. And if you haven't, please subscribe to that. A lot of good information coming out pretty regularly on the blog, so we would appreciate that as well. So at this point, I would like to just take a minute on behalf of our presenters today and thank everybody for coming out. I know it was a lot. I know everybody's processing it all. But our attorneys are here to help, so be sure you reach out to them with any more specific questions, and we'll get through it together. So on behalf of Courtney, Eric, and Brian, thank you so much for being here today, and have a great rest of the day.